Good morning, everyone, and welcome to the Federalist Society's first ever conference dedicated to artificial intelligence and the future of law and public policy. My name is Nate Kazmarek, and I am Vice President and Director of the Practice Groups for the Federalist Society. Before I run through some important housekeeping items for the day and introduce our excellent first speaker, I want to draw your attention to a podcast I came across this weekend, which was actually hyping this conference. The hosts were really impressed that FedSoc was calling for scholarly papers and holding important discussions around AI and the law. I will spare you from listening to the entire podcast, but I thought I'd play for you this morning audio of the first 90 seconds of the show. So we have a clip.
All right, get ready, because today we're diving into something pretty meta.
Oh, yeah.
We're talking AI
Okay.
and the law,
Interesting.
specifically an upcoming symposium from the Federalist Society called The Future of Law in an AI World.
Wow.
I know, right?
That's
That's going to be interesting for sure.
It is. And, you know, the Federalist Society, they're known for their...
Their conservative perspective on the law.
Right.
So it'll be interesting to see how that plays out.
It's like we're on the verge of, like, you know, the ultimate courtroom drama, but with algorithms battling it out instead of lawyers in those funny wigs.
Right, and speaking of drama,
Oh, no.
one of the topics is straight out of, like, a Black Mirror episode.
Really? What is it? AI is so smart it can write its own laws. Even creepier, think AI that can generate those realistic images and videos.
Like deepfakes.
Exactly, but like on steroids.
No way.
Yeah, and they're talking about using it to manipulate elections.
Like, hold on.
It's a paper by Ryan Bangert and Jeremy Tedesco.
Okay.
They're from the Alliance Defending Freedom, and they're really digging into how this tech, this generative AI,
Okay.
how it could be used to completely undermine trust in our elections.
I need a break already.
Like,
And
imagine
it's only been like 5 minutes.
election season just flooded with hyper-realistic fake news,
Oh my God.
all made by AI. How do you even combat that?
I don't know. That's terrifying.
Right.
Is there any?
The reason I shared that with you this morning is that I was really impressed at the level of detail they knew about our papers to be presented at our conference, their enthusiasm about innovation, and the appropriate level of alarm they felt about AI's potential negative impacts. But what is more mind-blowing is that this podcast recording was not between human beings. Rather, it was generated by AI using Google's new platform, Notebook LM. The technology allowed me to copy and paste the web address for today's conference and click a button labeled Generate. And in just a few minutes, an incredible 10-minute conversation was created. Truly amazing. And so I think it's very clear that these and many other technologies are improving at an astounding rate, and we will soon have profound economic, moral, and legal questions to answer. So it's fitting then that FedSoc would seek new scholarship several months ago and convene this gathering to wrestle with some of the most vexing challenges and dizzying opportunities of our time. At the outset, I'd like to say thank you to my colleague Steve Schaefer for his work in standing up the call for papers in April and his work with the editorial committee to set up the winning paper presentations today. I'd also like to thank Devin Patel for all his hard work. He was instrumental in helping it all come together so well today. We welcome our audience joining us via the live stream. We appreciate your viewership, and we look forward to your feedback. Two quick logistical notes for today. First, if you are seeking CLE for your attendance, please be sure to check in and check out using the QR code on the back of the program. Second, because of the number of papers and our tight timetable today, we will forego introducing the moderators in each of our panels today. The moderators will just come up and introduce themselves, and we will get going with the discussion. However, if you'd like to learn more about them and any of our presenters, please visit our website to read their full bios at fedsoc.org. Turning now to our opening address, we are delighted that Judge Stephen Vaden of the United States Court of International Trade can join us this morning. Judge Vaden has served on the Court of International Trade since December of 2020. Prior to that, he was general counsel at the Department of he was general counsel at the Department of Agriculture. In the private sector, Judge Vaden worked as an appellate litigator for two law firms, Jones Day and Patton Boggs. He clerked for Judge Julia Smith Gibbons of the U.S. Court of Appeals for the Sixth Circuit and Judge Samuel Mays Jr. of the U.S. District Court for the Western District of Tennessee. Judge Vaden is a graduate of Yale Law School, and his BA is from Vanderbilt. Many of you may have seen that Vanderbilt shocked the college football world this past weekend by beating Alabama. As a proud Tennessean and a Vandy grad, I half expected video to surface of the good judge carrying the goalpost from the stadium down Broadway and throwing it into the river. But I'm sure he was instead working on his remarks today, which he has titled, "A View from the Field, One Judge's Thoughts on AI." With that, please join me in welcoming Judge Vaden to kick us off.
Well, it's good to be here this morning with you all, and I must say that I did get to enjoy my alma mater's victory over Alabama, and that actually kept me from working on my remarks on Saturday as I traced the path of the goalposts, the 3 miles from the Vanderbilt campus to the Cumberland River, where they ended up. And until yesterday, in case you're wondering, because they have sold out, you could buy a 4-inch piece of the goalpost for $1,005. And they sold all 60 of them. But I'm here to talk with you today a little bit about artificial intelligence and to kick things off and to reference some of the things we'll be discussing later. I really would like to thank the Federalist Society for bringing together such an excellent group of scholars, judges, lawyers, and perhaps even a few people who know about AI to talk about the impact that this technology has had and will have on the practice of law. Artificial intelligence brings many new possibilities, but it will be grafted onto an existing set of problems and priorities that long pre-existed. And it is how this grafting will take place that will cause us to look back many years from now and say whether we adapted well or whether we adapted poorly. It's hard to believe, but when you think back, it was little more than a year ago today that many of the topics that will be discussed in the papers throughout the day first came to prominence. It was just about 16 months ago that we learned what a hallucination was, thanks to some unfortunate lawyers in New York City who were early adapters of artificial intelligence and therefore were able to inform us that artificial intelligence is currently, with regard to its legal savvy, somewhere along the lines of a first-year law student. If you don't know the answer, just make up a case. But that, of course, has kicked off a whole litany of reactions from across the state and federal government. And all of this has taken place in the span of little more than a year. From those initial pitfalls of hallucinations and promises of efficiency and worries about that we're going to see a real-life version of 2001: A Space Odyssey, we have had responses from all of the branches of government. And interestingly, some of the earliest responses came from our federal court system. As of the 1st of October, 24 different federal courts have issued specific orders on artificial intelligence. 18 of those 24 orders require some type of disclosure that artificial intelligence has been used. A similar number require the parties to affirm that everything they have filed has been checked for its accuracy and correctness, worrying about the hallucination problem. 3 of those orders prohibit the use of artificial intelligence entirely. And interestingly to me, only 3, including my own such order, address what to me is the largest problem that a judge should worry about, and a lawyer too for that matter, the potential for artificial intelligence to result in a breach of client confidences. If you're entering information into a computer system that is always learning and doesn't know what the attorney-client privilege is, the attorney work product privilege, or what business confidential information is, you should think about where that information may pop up if someone else enters the right query on their computer. And yet, only 3 orders of federal courts that have touched on artificial intelligence mention this at all. This may end up being solved simply by closing the universe of users and law firms developing their own internal AI engines, which only their attorneys have access to, solving most of the privilege issues. But it was notable to me that I had stumbled onto something in my order when LexisNexis last year purchased its own piece of the AI world, and then promptly, you may have noticed, changed their terms of service so that the next time you logged on, you got a big banner telling you that they now had AI, and then if you read the fine print, it told you whatever you do, don't take any of their proprietary information and enter it into somebody's AI system. States were not far behind, the laboratories of our democracy. My own home state of Tennessee passed one of the first acts seeking to regulate artificial intelligence, the so-called ELVIS Act, which stands for Ensuring Likeness, Voice, and Image Security. That law prohibits the unauthorized commercial use of one's voice and image, and it has civil penalties, including the ability for private parties to file lawsuits against anyone who knowingly publishes, distributes, or transmits such information without authorization. This is not creating a new law in Tennessee. It's amending a law that was first passed in 1984 to codify the so-called right of publicity and giving performers the ability to control the use of their own personal intellectual property for their own profit. But what's interesting and what's a recurring theme of the debates is that even in the state of Tennessee, as they were amending this law, they narrowed the pre-existing statutory safe harbors for those who are involved in the business of publication. Previously in the state of Tennessee, if you were engaged in fair use or any other protected use of someone's likeness, voice, image, you had an out under the ELVIS Act. The new version takes away that broader language that says there is an exception to the penalties under the law if what you are doing is otherwise legally protected, and instead now only says that the exception applies if what you are doing is protected by the First Amendment to the Constitution. How much that will end up mattering is yet to be seen. But you know, if Tennessee has passed a law regulating artificial intelligence, California can't be playing catch-up, and you would be correct. As a matter of fact, just this past week, Governor Newsom vetoed a bill that would have created an expansive regulatory regime in California seeking to regulate any artificial intelligence program on which someone had spent more than $100 million to develop or used a set in statute amount of computing power. That statute even had a provision that would have mandated a kill switch for artificial intelligence, so we didn't have to worry about future Hals trying to kill us. But that bill didn't become law. 2 other bills, however, did. Assembly Bill 2839 prohibits, and I quote, materially deceptive audio and visual media of a candidate, close quote, 120 days before an election. I suppose we shouldn't be surprised that when politicians worry about what new technology may do, they think of themselves first. And so that's the first thing that they have passed in California. But it also contains a provision requiring satire to have an express disclaimer on it. And that disclaimer is required to be at least the same size as the other larger fonts that are used on whatever it is the piece of media is that is being distributed. And in addition, there is a separate bill which has also become law, Assembly Bill 2655, which mandates that certain platforms are required to take down or otherwise label media that meets this materially deceptive standard. All of this, as you would expect, is currently tied up in litigation, some of which you'll hear about today, but certain of these provisions that I have mentioned have already been enjoined by a federal court in California. But whatever you think of the different bills that I have discussed here and the many more that are pending in state legislatures, at least when we're talking about the state level, we're talking about bills, things that have been debated by the legislatures of the states, considered by their governors, and either signed or vetoed. When it comes to the federal government and its responses to artificial intelligence, there's no need to give a special name to this conference. This might as well be just another meeting of the Federalist Society's Administrative Law Practice Group. Because all we're seeing is Congress has done next to nothing, and the executive branch is claiming that statutes that have been on the books for decades, of course, already cover every problem that you can possibly think of, and to prove it, they're writing regulations to show you that. Indeed, just over the past 6 to 8 months, the Biden administration has issued no fewer than 3 executive orders on artificial intelligence. One of them, known as the AI Bill of Rights, kind of interesting, they call it a bill since it never saw Congress. But anyhow, the AI Bill of Rights contains 5 principles that they claim you should be able to rely on when using or interacting with material created by artificial intelligence. And if that's not enough for you, in October of 23, they issued the executive order on safe, secure, and trustworthy development of AI, which adds another 8 principles on top of your pre-existing 5. Some of those include your right to security, the protection of equity, keeping worker protections and rights of unionization in place, and of course, ensuring privacy. And to help us administer these 13 different principles floating out there, the executive order creates a 28-member council comprised of various cabinet secretaries and heads of administrative agencies you have never heard of, who are supposed to coordinate this gigantic regulatory effort called for by the executive order and, according to its terms, somehow required by the Defense Production Act. You can look that up later. But where does all of this leave us? Again, keeping in mind that we are talking about developments. Everything that I just briefly listed there has taken place in just the past year. Where does this actually leave us with the promises of artificial intelligence? Because that's what's really exciting about any new technology, how it can help us, not necessarily how it can hurt us. As a judge who is jealous of private sector salaries, I hope that artificial intelligence will eventually lead to breaking the cartel that lawyers have formed and at least democratizing the average citizen's ability to get good legal advice free of hallucinations for the most common problems that citizens face. To me, when it comes to AI and the law, that would be the most welcome possible benefit. The legal industry is desperately in need of an Uber to break things up and lower prices. But I can't help but wonder, in thinking about the promises of new technology, if we haven't been here before and if there aren't lessons to be learned. This isn't the first time we've had a technology come before us that promises to change the world and might actually do so. We all remember, well, I think most of you, judging by the audience in this room, remembers when the internet first became a mass product and the changes that were promised and the changes that came. And looking back, I think we can say that overall, the benefits far outweighed the costs, but there were costs. And if you go back and you look at news stories from roughly 30 years ago, you will see that there were the alarmists of that time worrying about what this technology might mean, how it might wipe out jobs, how it might affect privacy, and other externalities that might come to pass. And the answer, frequently cited 30 years ago, just as it is today, was said to be regulation. And yet, something interesting happened. Congress actually passed laws, but it wasn't calling for regulation, it was calling for wait and see. And those laws prohibited special taxes on the digital economy at both the state and federal level. And they also provided some manner of liability protection from the trial bar for those who might wish to invest their capital or otherwise use this new technology to benefit the free market. And what do you know? With those two simple, broad protections, a whole new sector of our economy that did not exist before came to flourish and gave us new members of the Fortune 500 that did not exist 30 years ago. From Google to Microsoft to a revivified Apple to all of the many different companies from Oracle and what have you that spawned from that. All because a decision was made not to immediately regulate, as opposed to reach out and let's see if we control this thing in what the executive order promising trustworthy EI refers to as a state-driven model. My hope is, despite all of the fears, some of which I'm certain, unfortunately, will turn out to be accurate, that we can remember the lesson from the birth of the internet and apply it to artificial intelligence, because I strongly think that what was true 30 years ago remains true today. A light touch is best. Thank you very much.
Well, I think that was perfect, Judge. We very much appreciate you kicking us off. I'd like to call our first panel up to the dais. Our first panel is Ghosts in the Machine. What does AI mean for free speech and election integrity?
Thank you to the Society for hosting this very important and incisive event. My name is Aram Gavor. I'm the Dean for Academic Affairs at GW Law School and a professor. I teach constitutional law, federal courts, administrative law, and national security law. And I've been deeply involved with artificial intelligence from a scholastic perspective, as well as advising federal government agencies. And for disclosure purposes, I'm on the AI advisory board for Ikigai, a Series A startup. So the format for today is a really interesting one, and one that we can expect to often see in the academy, is that we'll be reviewing two papers that are very interesting and competitively selected. As Nate described, the first paper is titled "The Ghost in the Machine, How Generative AI Will Test the Bounds of the First Amendment." The reviewer for this paper is my colleague Paul Carranza, who is a professor of law and a concurrent professor of political science at the University of Notre Dame, so he's at the other end of the dais. He has served for many years as the director of the Kellogg Institute for International Studies, where he directs the Notre Dame Constitutionalism and Rule of Law Lab. His scholarly books and articles focus on comparative constitutional law, human rights law, and a fair amount of free speech. He also sits on Meta's oversight board. Just a quick introduction of the authors of the first paper. Ryan Bangert serves as the Senior Vice President for Strategic Initiatives and the Special Counsel to the president of Alliance Defending Freedom. He oversees ADF's government affairs and corporate engagement teams, as well as the Blackstone Legal Fellowship Program. He also advises the executive leadership with strategic initiatives and appears as counsel for ADF's clients. Prior to his government service, Bangert was a litigation partner at Baker Botts. And then Jeremy Tedesco serves as the senior counsel and senior vice president of corporate engagement for ADF. In his role, Tedesco leads ADF's efforts to combat corporate cancel culture and build a business ethic that respects free speech, religious freedom, and human dignity. Previously, he was an appellate litigator, and probably still is, on the legal teams. Of course, these are past cases representing Jake Phillips and Master P Cake Shop. And he was the lead brief writer on successful SCOTUS cases, Reed versus Town of Gilbert, as well as Arizona Christian School Tuition Organization versus Wynn. So to kick it off, the format for today is that we will ask the authors to present their paper to this group for 8 to 10 minutes. Then Professor Carrazza will provide 10 minutes of reaction, and then we'll have author responses and then some Q&A from the audience. And we'll do that times 2 for our 2 papers today. So please, feel free to kick it off.
Good morning, everyone. So we're going to move very quickly. So we are going to split our presentation between myself and my co-author, Jeremy Tedesco. Our paper is The Ghost in the Machine. We talked about the intersection between the First Amendment, free speech, and artificial intelligence. And our paper proceeds from a very simple premise, which is that the First Amendment safeguards one of the most profound markers and gifts of our humanity, the power to reason, to dream, to create, to love, and to share those aspects of our humanity via human speech. Artificial generative intelligence, or AGI, is daily testing the boundaries of our understanding of what it means to be human by performing tasks that we thought only humans could perform. So how do you square that reality with a First Amendment when the uniquely human activities safeguarded by the amendment are no longer solely the purview of humans? Now, common law famously proceeds by analogy, and by proceeding by analogy, the temptation is to afford the output of AGI unqualified First Amendment protection because the output mimics the creative work of humans most closely associated with protected speech, music, art, and even the written and spoken word. But does that analogy hold? As we point out in our paper, the court has long mapped the First Amendment onto new and emerging communication technologies like movies and cable television. But when it comes to the internet and information software, the court has oftentimes tended toward what we call techno-enthusiasm in its analogizing. This was exhibited by the court's majority reasoning in Reno versus ACLU, in which it enjoined broad swaths of the Communication Decency Act, excepting, of course, Section 230, concluding in its reasoning the internet was not nearly as invasive as radio and television, and far less likely a forum in which to encounter salacious content by accident, findings that are clearly dated today. And in Brown versus Entertainment Merchants, the court conferred sweeping First Amendment protections on ultra-violent video games, analogizing them to dime store novels and Grimm's fairy tales, of course not foreseeing the advent of virtual reality headsets and immersive video gaming experiences. My co-author and I contend that when it comes to AGI, we need to heed Justice O'Connor's invitation in her concurrence in Reno to take technology as it exists at the time, but with the knowledge and appreciation that it will evolve. And we cannot always see over the technological horizon. We also agree with Justice Alito's plea in Brown that the court should understand technology at a deep and foundational level before making sweeping pronouncements about when and how the First Amendment applies to it. In his words, the court must make every effort to understand new technology and resist the temptation to jump to the conclusion that new technology is fundamentally the same as older things with which we are familiar. So heeding his call, we took some time to assess the current state of artificial generative intelligence and its impact on the First Amendment. What do we learn? Well, AGI thinks in a sense, but not necessarily like humans do. It is an elegant probabilistic prediction machine. It requires massive quantities of actual power to operate. Witness the reopening of 3 Mile Island very recently, or the proposed reopening. It is capable of discerning deep structures in media, including human language. It is capable of self-learning in response to training stimuli through the application of complex loss function algorithms, and is capable of creating novel content in response to human direction by drawing on its deep learning. We also know, however, that most sophisticated LLMs, we don't know how they operate. We can explain why the output occurs, but we cannot predict the output in advance. High-powered LLM models do not provide identical answers to identical queries. You heard about hallucinations earlier today. The invention of facts that simply are not true. And in the language of the field of EAI, which is explainable AI, XAI, AGI is explainable but not interpretable. We can't open the hood, as it were, and watch the machinery in action. The model is stochastic. It's even non-deterministic. In other words, they're like the proverbial black box. Generative AI is somewhat of an anomaly, therefore. It is a human creation that can independently learn from human language and translate that information into convincingly human-like responses. Its creators can explain its responses most of the time, but cannot fully interpret them. It can be trained, but it has a mind of its own. It can speak. It can be nudged, but cannot be comprehensively controlled. It has access to far more information than any human can reasonably learn in a lifetime, but it can hallucinate answers to basic questions. So what import does that have for the First Amendment? When applying the First Amendment, the court has consistently pointed to the need for a, quote, willing speaker and something recognizable as a message, as a prerequisite for the existence of protectable First Amendment rights. And that raises some interesting and challenging questions when it comes to generative AI. Who is the willing speaker? Need it be a human? What must the speaker's relationship be with the output? Is it sufficient that a human be positioned exclusively in the recipient category, but nowhere else in the communicative transaction? Now, academics have begun to engage with these questions, and their findings have been mixed across the board. As to the necessity of a human speaker, the source, the literature on this point is highly under-theorized. But as a general rule, courts largely presume the presence of a human speaker when assessing First Amendment claims. This is evidenced somewhat hilariously, as we point out in our paper, in the case of Miles versus City of Augusta, a case involving the best analogy, I think, for AGI, Blackie the talking cat. A cat possessed of unusual elocutionary prowess that its owner predictably commercialized. But when its owner claimed Blackie possessed First Amendment rights to escape regulation by the city, the trial court rebuffed that move by pointing out that only humans possess fundamental rights. Now, as my co-author will explain, this is in alignment with Phil Hamburger and Jed Campbell's recent work on natural rights origins of the First Amendment as an anchor for human rights. The second question, what connection must be made between a human speaker and the output? And where do you locate those rights in the context of AGI? Well, one argument has been made that the speaker in the context of the output of AGI is the designer, the engineer who created the LLM. Now, that seems unlikely because, as we've discussed, AGI is not a deterministic processing machine. It's more of a tabula rasa mind whose outputs are not dictated in any narrow sense by those who set it in motion. And a small exception may be intentional guardrails set at the entry and exit points of an LLM, which look more like community standards and NetChoice. But that's an exception, not a rule. How about ownership? Is mere ownership of the LLM sufficient? Can we attribute the output of LLM as the speech of corporations that own it? Well, that raises the question of what is the basis for attributing First Amendment rights to corporations in the first place? As we learned in Hobby Lobby, it's really the corporation is an avatar to protect the rights of the human speakers who own the corporation in the first place. There is a connection between corporate speech rights and the humans who own the corporations. But what if that speech has no connection whatsoever to the volitional practices of the humans who own the corporation? Does the thesis hold? The third question is a special use case, and that is, are the users, are the recipients of the speech, are their rights to receive speech sufficient to confer First Amendment protection to the output of AI in general? Now, while this move may sound superficially promising, it cuts against the assumption sub rosa in the court's jurisprudence addressing listener rights that a speech transaction involves a human source and a human recipient. And as my co-author will discuss, that unmoors First Amendment doctrine from its natural rights foundations. So with that, I will turn to my co-author for a brief explanation of our analysis of NetChoice as well as the natural rights foundations as applicable to AGI.
Thank you, Ryan. So it's my pleasure to present today on NetChoice and its applicability to AI, which is fleeting. NetChoice, of course, involved the Texas and Florida laws that imposed third-party content requirements, must-carry content requirements on social media companies of a certain size and character. And the court found that in certain instances, on certain platforms, that those requirements did indeed run afoul of the First Amendment. But to the extent that those opinions cover AI in any way or have implications for them, they ultimately don't provide a lot of clarity, and the opinions themselves are fractured. So let's look at those opinions quickly and just glean what we can from them. 4 justices, Kagan, Sotomayor, Roberts, and Kavanaugh, appeared willing to grant broad First Amendment protection to the curation of content on social media platforms without regard for whether that activity was the conscious product of human decision-making or a purely algorithmic function. As the majority put it, the government may not, in supposed pursuit of better expressive balance, alter a private speaker's own editorial choices about the mix of speech it wants to convey. The majority seemed content with the presumption the algorithmic construction of content streams, as practiced by Facebook and YouTube, was an expression of social media companies' corporate policies governing the use of their platforms. 4 justices, for their part, Alito, Thomas, Gorsuch, and Jackson, declined for varying reasons to join the majority's conclusion that the First Amendment prevented state laws from imposing a viewpoint neutrality requirement on social media platforms' content moderation policies and practices. They were unified, however, in one way, and that was in their unwillingness to extend full First Amendment protection to those practices as instances of expressive activity without first understanding precisely how those functions operate. This left us with Justice Barrett as the pivotal deciding vote in NetChoice, and while she had joined the majority in full, she wrote separately to express the limits of the court's decision. Specifically, and I think important for our purposes, she called out 2 forms of algorithmic activity that the First Amendment may not reach. She questioned whether expressive activity occurs when an algorithm just presents automatically to each user whatever the algorithm thinks the user will like. And second, she questioned whether expressive activity occurs if a platform's owners hand the reins to an AI tool and ask it simply to remove hateful content. In both instances, she posited that the use of this sort of technology could attenuate machine output from a human expression in a manner that has constitutional significance. Now, the task of applying the First Amendment and its precedents to rapidly evolving AI technology is certainly a daunting one, facing lower courts, and NetChoice provides little clarity to them on how to figure out those questions. Ryan and I humbly recommend 2 guideposts to courts facing this challenge. He's already foreshadowed both of those. First, courts should exercise judicial modesty when deciding free speech challenges to laws affecting AI, deciding only so much as the case is presented and only on a factual record that details how the technology operates, especially related to the question of who is speaking and that attenuation question. Justice Alito championed this kind of judicial humility in both Brown and NetChoice, and his criticism of the majority in NetChoice was almost like him pulling his hair out. At one point, he exclaimed, and when he was explaining how when AI algorithms make a decision, even the researchers and programmers creating them don't really understand why the models they have built make the decisions they make, as Ryan was describing earlier, the black box problem of AI, generative AI technology. And Justice Alito goes on to say, are such decisions equally expressive as the decisions made by humans? Should we at least think about this? You can see him railing, on the desk, on the podium. This epitomizes the kind of judicial modesty that we think is necessary to decide these kinds of cases, but it also points to the second principle that Ryan alluded to, and that is that to decide these questions, we think we must return to the natural rights roots of the First Amendment. Our law privileges speech for a reason, and that reason has to do with the nature of speech itself. The Free Speech Clause is not a utilitarian exercise in positive lawmaking, but rather a civil guarantee of a natural right. Natural rights, by definition, are rights possessed by human beings. The founders understood natural liberty to be the freedom an individual could enjoy as a human in the absence of government. Natural rights, then, could be roughly understood as the human liberty to act. Viewed historically, the First Amendment did not enshrine a particular rationale for expressive freedom. Instead, the First Amendment recognizes the natural right to freedom of expression and establishes positive legal boundaries against government infringement of that right. This natural rights approach to questions involving the First Amendment and generative AI would prevent conferring constitutionally protected speech rights on non-humans, including AIs, because non-humans do not possess a natural right to engage in free speech. In this sense, affording AI a constitutional right to engage in free expression would be a category error. But this isn't to say that content carried or created by AI could never constitute speech. Rather, a court would need to ascertain whether such content constitutes human expression before extending First Amendment protection to it. And again, on this score, Justice Barrett's concept of attenuation holds promise. While at this point it lacks the formal rigor of a legal test, attenuation provides the beginning of a framework for assessing whether AI-generated output should be evaluated as constitutionally protected speech or something more like an expressive product. The upshot of the natural rights framework is this: generative AI applications that enjoy First Amendment protection should be those in which an identifiable human speaker seeks to communicate a recognizable message with a human audience. Adopting such a rule would not constitute an exception to well-established First Amendment principles, but rather would be fully consistent with the bedrock purpose of the First Amendment to protect the very human act of communication. Thank you.
Thank you, Ryan. Jeremy. Paolo, your comments.
Okay, thank you so much, Ryan, Jeremy, for this really interesting paper. Its broad sweep of the current law and the uncertain state of the First Amendment is really helpful, as well as its description and synthesis descriptively of the operation of generative AI in particular. I think is a really useful synthesis. And above all, what I regard as the biggest takeaway, which is the end, the return to first principles, I find enormously important and appealing. So I'm going to start with that and then back down to some of the more specific questions that I would have that it brings along the way. So the core idea here, I think if I could state it maybe even more kind of compactly than you have in your presentations, is simply this, that how we should approach the regulation and even just the thinking about AI and freedom of expression here turns on the problems that are created by the distancing of actions taken by AI from human agents and agency, right? The problem of, as the paper says in various points throughout, the problem of attenuation. And in fact, then you propose towards the end what you describe on several occasions as an attenuation framework for analyzing the implications of that. So that would mean, as I understand it, where the connection between human expression and action is closer, it's more likely to constitute constitutionally protected speech. Where the link between those two is more attenuated, there's less protection because human expression is less implicated, as opposed to simply non-human machine actions. Now, I think there are many virtues to that first principles approach and that attenuation framework that I'll start with. First of all, just intuitively, it makes a lot of sense to us. I think it concords with the grounding of freedom of expression, not only historically in our constitutional tradition, but even today in a sense of that freedom of expression has to do fundamentally with our personhood, right? The dignity of persons, as you state quite explicitly, and that human agency is fundamentally constitutive of that dignity. And that's true across all sorts of different theoretical traditions that we share and that are part of the American constitutional kind of inheritance. And that means that an approach that conversely would focus merely on the social utility of freedom of expression is not adequate to the problem. Now, that's not to say that freedom of expression doesn't have essential social purposes to it and social ends. But the best theories of the protection of fundamental individual rights unify these things, right? That the protection of human dignity and the realization of the common good are in fact inseparably intertwined. And I think that's the point that you're trying to bring out by going back to first principles. I also think it's a virtue that it corresponds to a deeper challenge of AI that your paper points to, but goes well beyond and is very much the subject of the entire day of presentations that we're dealing here, and the very title even of this gathering, the future of law. Right. The governance of human action and behavior by algorithmic processes, which metaphorically we'll call reason, algorithmic reason, even though we all know it's not really reason, okay, is a problem for all of law. And this is just, I think your example is helping us to see how we should be asking the question of the attenuation of human agency from the outcomes of decision-making as really posing grave questions and risks for law in general. The distancing of actions and determinations from human agency, from human reason, from human judgment, this offloading of all of those things onto algorithms, has profound implications for law more generally because of it poses into question the very idea of law as the making and applying of decisions of collective responsibility in our political and social environments. That responsibility is deeply dependent on an active moral agency by deliberating human beings. So any action that attenuates that connection and makes it atrophy, I think poses broad challenges to the whole idea of the rule of law, and freedom of expression is in some ways just an early sort of harbinger indicator of that larger problem. And lastly, I think the return to first principles also helps bring out an essential link here between human freedom and human responsibility as well. I think part of the return to the natural rights tradition that you appeal to my mind, is important precisely because that tradition has always emphasized the reciprocity of rights and responsibilities at a social level. And here, that is a problem we very much face in the ecosystem of the digital information space. Just the many debates over Section 230 of the Communications Decency Act, for example, and the really wonderful because it's so provocative, Third Circuit decision that you use and highlight in Anderson versus TikTok that was just decided less than 2 months ago, it brings out that problem. It's Section 230, one of the things that we're struggling with right now is the way that it provides certain kinds of editorial immunities, but not editorial responsibilities. That paradox comes out exactly in some of the contrasting litigation in the Supreme Court over the last couple of years. You've highlighted the NetChoice cases where there's this very strong affirmation of First Amendment immunities, and the platforms emphasize in those cases that they're exercising editorial responsibilities, right, and editorial discretion. But go back 1 year to the Tomna and Gonzalez cases, and you see the platforms taking exactly the opposite position. Well, we're not responsible here because we're not exercising substantial editorial responsibilities, and that was the basis for their not being held liable there. And so there are deep contradictions here in the relationship between rights and responsibilities that I think is also a virtue of your appeal to go back to first principles of what are the rights, what are the fundamental human interests that are at stake, and how is human agency implicated in the operation of this technology? Now, that said, turning sort of the other half of my remarks is that the attenuation framework also raises lots of questions and difficulties in fleshing it out, some of which you acknowledge, lots of challenges. You acknowledge it lacks a developed rigor that would be necessary to use it to guide law with sufficient specificity. Part of that, I think, is there's a conceptual ambiguity in what is the attenuation problem exactly. Is it that the output is being separated from the intentionality of the actors? Is it that it's being attenuated from the foreseeability of what's going to result? Or even more strongly, is it being attenuated from the control of the actors? All three of those are not quite the same things, and I think we would need to understand better what that means. You've described the attenuation framework fundamentally as, quote, whether state action impinges on human expression. But I wonder whether it's better to describe it from the other direction, as whether communication is expressive of human agency in a meaningful sense or not? And does it make a difference which direction we're coming at the question of attenuation from? A second set of questions would be, in the paper as a whole, as we're thinking about the attenuation framework, is there a greater distinction to be made between AI-generated content and the moderation of content through AI? You address both of these problems, and I'm not sure that they need to be that for analytical purposes, they shouldn't be separated out. I think there are many more questions about the analogy to editorial control than to the creation of content here that arise. And thirdly, in both of these areas, in a certain way, I don't think it's unreasonable to regard AI, even when attenuated from human agency, as, in some sense, an instrumentality of human agency, a tool to be used. So even when the results are not fully predictable and they are distant, nevertheless, they have been put in motion by human agency for human purposes, and the accountability still needs to be there because of that. So in the generation of content, even though AI can, in some senses, be put in motion, it's almost always done so by being prompted by human beings for some sort of expressive purpose. And in the moderation side, as much as, I love sort of, it's conceptually attractive, what Justice Barrett has laid out in the NetChoice concurrence that you highlight, I think it's as factually implausible as it is conceptually attractive, right? In other words, content moderation is always a mix of expressive curation decisions and non-expressive sort of automated product production. And I think it's virtually impossible to disentangle them in the actual practice of what's going on the platforms. It would be almost like saying, to go back to a different era, that producing a newspaper has the non-expressive dimensions of printing and distributing, and those can be disentangled from the expressive dimensions of what to choose to put in the newspaper in terms of content. Lastly, I think that the focus on responsibility that comes out that I mentioned earlier also raises questions that are that in some sense go beyond your paper, but you touch on them briefly about the downstream negative implications of the uses of AI. Even uses that are designed to act in ways that are expressive of human agency. And I'm not sure that we have the resources yet in the principles that you lay out to grapple with what are, I think, increasingly undeniably distinctive and unique kinds of harms that arise out of the use of not just generative AI, but social media in general, and the combination of generative AI with social media. The extent to which it is designed specifically in forms that are intended to prey upon certain kinds of psychological vulnerabilities that are inherent to the human being. The scale and pervasiveness and speed with they're generated raise distinctive kinds of problems. And we're seeing now in the debate over harms, developmental harms to minors, for example, the way that questions arise that, on the one hand, make it very clear that your skepticism about, techno-utopianism is quite warranted. But all of those things, I think, to borrow a phrase from my Notre Dame colleague, Randy Kozel, and some of his recent work on First Amendment, puts the content under pressure. And you are wanting to go back to these first principles and establish this connection between human agency while still preserving, as much as possible, the content-neutral traditions of the First Amendment. And I fully agree with that instinct, but I also wonder how easy it is to maintain that, right? Or to put it a different way, don't we need to come to more terms with the actual content of what's being produced from a First Amendment point of view? You rightly point out that the Supreme Court has always resisted, and again, I agree with this resistance, to the creation of new exceptions to protected speech under the First Amendment. And part of my sympathy for that reluctance is, as a comparatist who works a lot in Europe, I look at the European models of regulation and the increasing, what I regard as worrisome erosion of protection of freedom of expression in the European framework. And I think that, but I don't know how we can square that circle, and I'd love to hear more from you. And then very lastly, just a couple phrases. Judicial modesty, yes, absolutely. That's something we should all be behind here. But let's not focus only just on judicial modesty, but on also legislative responsibility. It's not enough for the judges to be restrained if there's a vacuum. And right now we do have a vacuum of public responsibility over legislating in this area. We're facing technologies that are exercising unprecedented, I mean literally unprecedented in all of human history, power over freedom of expression on a collective scale. We need standards, we need accountability, we need to figure out better ways of addressing this that go beyond simply judicial restraint, but go to collective responsibility, both legislatively, and I will add, sort of appealing and anticipating the next paper that we're going to hear about, the kind of responsibility that is exercised through private ordering, through self-regulation, and through a constructive collaboration between the public sphere and private actors as well. Thank you.
Thank you, Professor Carrozza. So just to keep the trains on the schedule, Ryan and Jeremy, I'll ask you to try to unpack that in a couple minutes, if you can. Maybe focusing on the biggest highlights, just so we can
Certainly.
Talk about the second paper.
No,
today.
I
really
very much, very much appreciate Professor Carrozza's commentary, very helpful. I think you correctly identified the fact that this was the anti-Skynet paper. We're trying to prevent Skynet from overtaking the world, so we certainly wanted to ground any conception of the way First Amendment interacts with AI in a place that's very human. We want to preserve the human aspects of the First Amendment. We don't want the First Amendment to become an excuse to prevent regulation of AI in places where there is no expression, there is no actual effort to create a human message. And so I think from that perspective, that's what we were trying to get at in our proposal with respect to attenuation and judicial modesty. Because we certainly have seen moves, at least certainly early on, to exempt the entire enterprise of artificial intelligence from any form of legislative regulation. That's where I would start with respect to your comments. You said we need to have at least an effort by the legislative branches to engage this, seeing as an effort to disable that from happening by throwing a First Amendment blanket over the entire enterprise of AI simply because AI engages in something that is a simulacrum of expressive conduct. And so we were looking for ways to allow breathing space for the legislative branches to engage in this enterprise by not simply having a First Amendment exemption for all AI-generated output. But you do raise a number of excellent points with respect to gaps and need for further development in the theory. And I'll raise a couple of those here, because I think they're very helpful. One of the things you pointed out is you said it's not unreasonable to require artificial intelligence, at least in this sense. You said, is there a way that we can distinguish between AI-generated content and editorial control? And that's where I wanted to go, because I think that was a very prescient point. I agree with you that those are two completely separate enterprises, because editorial control, as the Supreme Court spoke about in NetChoice, does implicate human decision-making. And one of the things that we noted in the paper, although we did not develop it with any real rigor, was this concept of guardrails and the various aspects of training of AI. So AI goes through three different phases of training. The first phase of training is really an undirected phase, where the algorithm simply ingests petabytes of information and more or less engages in a process of self-learning. Following that, there's a second phase, which is what they call fine tuning, where there are pairs, and you probably are very aware of this with your work with Meta, the pairing of human responses with scripted outputs. And then there's a third phase, which can now be called RHLF, where humans get into very granular training of the AI. And then on top of that, you can insert guardrails on either side of an LLM to exclude certain inputs or exclude certain outputs coming. I agree that those are instances of human agency, where humans are exercising agency to exclude certain messages or to force the AI to engage in certain messages. And it seems to me that there's insufficient attenuation there to exclude First Amendment consideration for those choices. The question that you raised, though, which I think is really where the rubber meets the road, is can you disentangle those aspects of the AI process from the aspects of AI that don't involve any human volition or agency at all? And that, to me, is a very important question. Quite frankly, I don't know. And I think that that's why we call for judicial modesty. Instead of throwing a blanket of the First Amendment over the entirety of the process from the very get-go, because there wasn't sufficient, quite frankly, in NetChoice, there wasn't sufficient development of the factual record to make those kinds of distinctions and make those kinds of choices. We need, I think, to have some test cases. We need to have some real development of the factual record and apply the First Amendment under those conditions, not simply on summary judgment like we had in NetChoice, to get to ground on some of those questions. But I think the through line that we propose, which is there needs to be some volitional aspect of human agency involved in order to apply the First Amendment, holds true. But how you apply that, I think, is going to be to be determined, TBD, based on the factual development that we hopefully will get in future litigation.
In the interest of time, I'm going to yield my time back to the moderator.
Thank you so much, Jeremy. Ryan, really appreciate that. And Paolo, I'm still thinking through your comments. I have so many of my own to offer, but I think I'm going to do so in writing. Just so we can give space to our second paper, for which I'll be the primary commenter. This is Protecting Election Integrity from AI by Defining Impermissible Uses Rather Than Impermissible Technology. Our two authors are Andy Craig and Bartlett Cleland. Andy is the Director of Election Policy at the Rainey Center at Cato. He is focused on election law, electoral reform, and political incentives. And his work has been cited and referenced bicamerally and through a numerous amount of news outlets. Bartlett serves as the Executive Director of the Rainey Center's Leadership Alliance for a More Perfect Union, otherwise known as the LAMP program. And he interfaces with legislators across the country, and he runs various programs and seminars. He also worked for Americans for Tax Reform as a Technology and Policy Council. So, gents, please, if you can, maybe 10 minutes total to discuss your paper, and then I'll give you my thoughts.
Cool, thank you. Thank you, panelists, thank you, professors. My mic is on or not? Okay, cool. And the audience here and who are watching live stream. So I've got a couple great pieces of news. First of all, there will be no Skynet, at least under today's AI, and that's part of what our paper was meant to convey. And that is, what is AI? And then Andy is going to pick up more on the election side. So I'm going to lay out the AI issues first. So we've heard a lot of today kind of muddled AI talk. And so I think as attorneys, we have a responsibility, not just to the courts, frankly, in policy. And I work vastly with legislators, not with judicial branch, on getting our understanding of and then definitions, if things can be defined accurately in the law, correct. So let me walk you through the current state of what has been thrown together as one batch, including in the title of the conference, as just AI. There are at least three pieces. We could get more granular, but let's say there are at least three pieces. Number one is what's called machine learning. You have been using this for 40, 50 more years. Machine learning has been around for a very, very long time. You might intersect machine learning today in things like facial recognition, like your phone is loaded with machine learning, honestly. Facial recognition, spam filters, predictive text. right? You're typing, it's putting the next word up. That is machine learning. It has learned a little bit about you, but it has been programmed with algorithms, all done by humans. So there's constant human interaction, constant human expression throughout the process. The other places you'll find this outside communications, because we need to remember that AI, again, broad AI, is much broader than just in communications. We tend to shunt aside the AI we don't see. In machine learning, you don't see most machine learning. You don't encounter most machine learning. Where is machine learning used a great deal? Finance and social media optimization, for example. You don't see it, you don't control it, you don't do anything with it. It is working there to help optimize experiences or make more accurate direction for what you are doing. How does this work? It is not magic in a box. It's not that we don't know what's going on. In fact, we completely know what's going on. What we don't know is all the information in the world. And so we have an enormous ego problem in this area, where we believe, as humans generally, that if I can't do the same thing the computer's doing, it must be thinking, it must be going beyond me. That's not true. So take a simple case like chess. So with great fanfare, not many years ago, at least a couple times with a couple different technologies, grand chess masters were beat by computers. This is not a mystery. The computer is not smarter than the chess master. If you think about the game of chess, there are a limited number of moves. Turns out it's like 18 billion moves through the whole. There is no human chess master in the world that will play 18 billion rounds of chess and anticipate every move that you may or may not make. The computer can do it all in the blink of an eye. It's a function of speed, a function of storage, not a function of whether we understand the algorithm or the expression, et cetera. That is what's going on in the background. So I just want to dismiss this notion of this magic box. That we heard the exact same type arguments. We heard arguments both on Capitol Hill and in judicial areas with that same undergirding understanding, which was a lack thereof, being said often around the internet. Turns out internet's not that complicated. It's not that hard to understand. Engineers understand it. Anyone engineering AI understands what they're doing. There is no Merlin in the back room waving a wand. Next step is generative artificial intelligence, which is what we are dealing with today. This is ChatGPT, image generators, for example. Generally, it's creating new content from human input. It's not creating content on its own. You don't set it over there in the corner and it starts doing stuff. In fact, that looks a lot more like the last part of AI, which I just call science fiction, which is like Rosie the robot. That is referred to as artificial general intelligence. I didn't name these things, by the way. I know they sound the same. They're not the same. It's generative artificial intelligence and artificial general intelligence. That's Skynet. That's when someone suggests the Skynet or Terminator, generally a clue you've got someone who's a little bit scared of technology or the implications. I use Rosie the robot because it's very optimistic. And as I look around the room, maybe most of you know the Jetsons. I hope you do. So Rosie the robot always knew what George wanted, right? It was always helpful. We'd even give him solace at times. That is artificial general intelligence. That's a totally different track. It is science fiction. So now, could it happen? I don't know. Dream up any other dream that Isaac Asimov or H.G. Wells have created that we don't have yet and decide whether those could happen. They might. But that's not where we are, and that shouldn't be what we're spending our time on legislatively, much less in a judicial way. And essentially the definition there is that is intelligence that would match human cognitive capabilities. I think we can all agree your phone is not there. That's not what it does. I think I will stop there so that Andy has any time to talk about the actual election side of this.
Sure. Well, thank you for that, and thank you everyone for being here. So we heard just off the top from the judge in our presentation a little bit of callback to the early days of the internet in the 1990s. Kind of what got this started for me was a little bit later than that, the early 2000s, when Photoshop was becoming a thing. And also computer-generated image in movies, and so digital image manipulation was becoming a thing. And we heard a lot, you might remember some of it, about how this was going to flood us all with misinformation. Nobody's going to know what's real anymore. Photoshop's going to kill us all. As it turns out, there was a case for the more techno-optimist side of things because norms developed. The technology was not as potent as many people feared. The internet will very quickly call you out these days if you try to get away with posting some altered image, including generative AI now that it's being done that way. But this has been around for a while. And as you're walking through the history of applying the First Amendment or free speech principles more generally to new technologies, there is a bit of a pattern where, as Mark Twain said, history doesn't repeat, but it does rhyme. And when we got broadcast, that was new, that was different, that was powerful in a way that prior communications media had not been. But we got some really bad precedents and some really bad laws out of that and out of those early misunderstandings. We had the Fairness Doctrine for decades. We still today have a special kind of First Amendment exception for the 7 dirty words, which seems so quaint in the era of the internet, but it's still on the books. That's still the law. The FCC will still fine you. And looking all the way back to the origins of the First Amendment itself and the centuries that preceded it, the advent of the printing press brought us the wars of religion. It brought us the literal licensing of the press. And it took a long time before, it was a couple hundred years at least, before we first hit upon kind of codifying the First Amendment for that. So I do think there's a reason to be both on the technical optimism side and a little bit on the skepticism side of we have to rush in here with new regulations for something that is still, for all intents and purposes, a couple years old. The disruptions that we're going through from it, which are real and we've all seen, have not yet had their time to shake out in the kind of cultural marketplace, the marketplace of ideas, the economic marketplace. There's a lot of people who think AI is a bit overvalued on the economic side at the moment, and we'll see how that goes for OpenAI and companies like that. Could be a little bit of a tulip mania going on. So with that said, in the election context in particular, because Bartlett's background is in tech, my thing is election laws. I recently got asked by a reporter, how will AI affect the Electoral Count Reform Act? And I didn't have a very plausible answer for anything I could come up with on that one. But we have seen a lot of these things come up. You probably noticed there's an election going on. And so there are a few kind of buckets that we've seen these things come up. But we talk about in our paper one incident in particular that got a lot of media attention in New Hampshire. Before the New Hampshire primary, there was robocalls with a AI, I won't use the right kind of AI to describe it, but imitation of Joe Biden's voice, discouraging people from voting in the New Hampshire primary. And this, again, got a lot of attention. But state charges came down, the FCC came down and fined them, and the charges, both on the civil and the criminal side, had nothing to do with the fact that AI was used for it. On the state law side, they had a false disclosure. They claimed that this ad, bought and paid for by so-and-so was not actually the group behind that ad. They were, so that's just straight up, you're not allowed to do that. When it says Joe Biden approves this message, it has to be Joe Biden actually approving this message. It doesn't matter if you had an AI or a Joe Biden impersonator do it. And then on the FCC side, they violated rules about robocalls. So we can have valid enforceable laws about disclosures, the same way we're used to for campaign finance regulations. We do have, both in general and in some election-specific contexts, laws against impersonation. You can have the personality rights laws that are publicity rights that apply more generally. There are also some laws that are kind of the inverse of the disclosure requirement, that you can't falsely claim to be speaking for a candidate or a committee, whatever the relevant electoral entity might be. You can't do false info about voting. So this is something Department of Justice has been nailing ill-advised people for a long time on, is conspiracy against rights, which is very broad, very vague general statute, but one of the theories that it's been interpreted to apply to is if you do something like a text message blast saying, you know, don't forget to go vote on Wednesday this year instead of Tuesday. That's illegal. That is a conspiracy against civil rights, and you will go to prison for it, and it does not matter if you wrote that text or if you had ChatGPT write that text. And so as you walk through all these examples, and I'll touch briefly on voting machine security too and then wrap up, but the bottom line is that all of these things we're worried about, the current laws already go at or pretty near the First Amendment maximum of what can be restricted. And beyond that, there are First Amendment precedents. You can't generally ban lying, and false statements in and of itself is not something we can ban in political advertisements. There was a case about that. So the key thing here is we just need to clarify that all of these existing laws and all of these existing harms we're worried about just need, AI is not a loophole. It's not a get out of the law free card. The AI might not have human agency, but the person that you can go and put in prison very much does. And somebody is behind whatever it is you're trying to go after and all these kinds of malfeasance. And then lastly, this is one that gets brought up also about the security of voting machines, election infrastructure. I am not a software engineer. Do not ask me to set up antivirus on your computer. That's not my area. But when it comes to these machines, the safeguards are largely not software, they're physical. The machines are air-gapped. The machines have no connection to the internet. They have tamper-proof seals. They are audited against the paper ballots, which for 99% of votes in the United States are already recorded on individual paper one way or another, but it's all on paper. And so, this idea of Rosie the robot as a super hacker who's going to come in and corrupt our ability to count votes accurately, that is, again, something where it's not a new threat, and we already have pretty good tools to handle it. So that is my my techno-optimism regulation skeptical case for how to think about AI in elections.
Thanks so much, Andy, Bartlett. So this paper is a really well-timed and interesting one because, frankly, when you drafted it, you were laying out predictive hypothesis, and then obviously we're going to see what happens, and we're seeing what's happening, and makes sense. I would recommend you essentially conclude it after November, and then you can sort of take that insulated and then push for a normative outcome as to what follows. So your thesis makes plenty of sense, very easy to track, is that de-emphasize technology-specific regulation, focus on use case using existing statutes. That makes sense, and you encourage the Federal Election Commission to take action. So the one point that I wanted to ask among a couple, just given the time that we have, I've sort of truncated my thoughts, is that on September 10th, in response to Regulation 2023-02, the Federal Election Commission issued a declination to engage in rulemaking with regard to AI specifically. So it's at least 4 commissioners acted to forbear on that. And that doesn't necessarily mean that your thesis is adversely affected, but it certainly means that the FEC is taking a very careful, thoughtful, some would argue measured approach to seeing how it plays out. And then, of course, it doesn't take a lot to see the news because a lot of this is above the fold stuff. There's a lot of FEC complaints coming in right now involving a lot of AI-related information. The second point of the 3 that I wanted to lay out is that the Federal Election Commission specifically is exempted by a lot of congressional action with regard to AI itself. So, for example, Executive Order 14110, that's the October 30th, 2023 EO. That's perhaps the longest EO of all time. Involves 20 different agencies and 50 different actions. and then required the spinning out of not just one, but two OMB memos, M2410, and then just last week, M2418. The statutory hook actually exempts the Federal Election Commission, which is really fascinating. So that would be Title 44 statute, Section 3502, Part 1. So there's FEC exceptionalism even in the broader milieu of an enormous amount of executive branch regulation of not just traditional cabinet level agencies, but also independent agencies too. So I was interested to get your thoughts on accounting for that. And then the third piece that I really wanted to ask about, specifically involving the technology itself, is whether there is a space in the Help America Votes Act, if I recall off the top of my head correctly, HAVA, and the U.S. Election Assistance Commission, whether, especially with regard to a voting integrity standpoint, there's any good judgment associated with impinging upon federalism principles by laying out best practices or something like that with regard to soliciting requests for federal grants.
Sure. Well, I will take the last one of those first on HAVA. That is a longstanding thing. The Election Assistance Commission has voting machines that meet their standards. There is some federal funding tied to if states use that, but states don't have to. Not all states do. So if you're looking at just kind of the cybersecurity angle, there it is, as a practical matter, useful. You know, if you're in the Secretary of State's office in Cheyenne, Wyoming, you're not necessarily going to have a lot of software engineers who are on the state of the art of this stuff. So there is just some practical assistance, but it's not a mandate. States don't have to do it. States can go their own way if they want. And on the FEC, a lot of that comes out of the fact that the FEC applying campaign finance law is in a very touchy First Amendment area already. And so it is generally more difficult to get all willy-nilly with executive orders when you're the FTC. You have to have a pretty firm statutory hook, and you have to have be pretty well within the four corners of existing precedents. So that's why that is. And also, a lot of people often misunderstand. The FEC is pretty much only just campaign finance. There are a lot of other laws about deceptive practices, and unless it's touching somehow on the transparency and disclosure requirements of campaign finance, most of those things are going to be falling under state law, mostly civil law, some criminal laws. But it's not going to be the FEC coming in and shutting down a candidate for using an AI-generated image in an ad or something like that.
Bartlett?
Well, all those questions were squarely in Andy's wheelhouse, so I don't have any direct response to the FEC.
Well, what about the declination to engage in rulemaking on the FEC's front? That obviously touches on the technology piece as well, and your paper specifically does recommend laying out AI-specific regulation.
Sure, well, yeah, and guidance, I think, is more of what our thinking was there, but along the lines of what Andy already illuminated in HAVA, I think along those same lines. So
That makes sense.
as a very quick vignette, so I have had the great opportunity to travel to, I don't know how many states now, to sit and talk to secretaries of state and county clerks. And the variety of issues that come up are frankly mind-boggling. What almost never comes up is technology, specifically. Now, it might come up as some general, and Andy addressed this in his comments, so you will hear, we have constituents, we have citizens who are concerned and are adamantly believe that once they vote, that somehow that vote is exposed to the internet. And I'll have Andy check my work here, but there is virtually no jurisdiction where that happens in any way, shape, or form, again, with the air gap. And so what I tend to hear when it comes to any kind of technology where the FEC might then be concerned, it's largely a non-issue. Where the AI comes into play is much more in the campaigning. So In fact, there was just something the other day that the headline was very misleading. It said it was about AI. It appears that it was probably about Photoshop. Someone had changed a sign at a Harris rally that was something negative. So that is typically how it comes up. And again, to Andy's point, that's not generally where FEC plays. And to the extent that they do, there are laws that cover virtually all of this. What I would recommend rather than FEC is that states make sure that their election laws, when it comes to communications, that if for some reason you could argue that AI-generated content wouldn't apply in the definitions, that they stitch close that definition and make it more holistic, as opposed to putting in a new AI law, which makes very little sense.
Thank you. We have, I think, time for maybe one or two questions. Seeing that there, oh, I see one coming up.
I can confess I'm a simple labor lawyer, so but Andy and you guys, I think you sort of downplay the concern over a lot of these areas, because I think you were saying state laws govern, or FEC governs what happened with the Biden robocalls and all that. But doesn't AI exponentially increase the ability of bad actors to do those things you're talking about? So you're right, it might be governed by that, but in a world of limited enforcement resources, which of course we have, whether it's state or federal, it seems to me as a labor lawyer, the universe is vastly expanded to do bad things by the use of AI, even though it's true it could be regulated by state laws, or et cetera. Is that not a concern?
Well, the limit on that there is you have a limit on how many people there are directing the AI to do the bad thing. I mean, that robocall, yeah, you can produce, there are already ways to do this. You can produce a flood of text messages or videos or audio or whatever, but it's the choke point there is the people actually doing it, and those are the ones breaking the law. And so that's where you might need more enforcement resources, but the exponential explosion is not an exponential explosion in people who are willing to commit these felonies and take that risk.
And I'll just add, we have, let's stick with what we've already talked about, but we have the example of Photoshop. Photoshop arguably would have been the same. It made it easy. I mean, you and I can use Photoshop, or maybe I shouldn't throw you in the same bucket. I'm not very creative, and I could use Photoshop. And theoretically, that expanded the realm of people who could do harm in an election, faking photos, et cetera. We ultimately saw that wasn't a problem, and I think part of what if we follow your logic, I think, what you would end up with is every time there's a new tool created, we would have to first lock it down until we figure out how many bad actors there are out there before we let the good actors go forward with it. And I find that to be a disturbing approach to how we should think about jurisprudence.
Thank you. Last question for this panel.
Yeah, thank you. Brent Skorup, Cato Institute. This is for the authors of the first paper. I was curious, you spoke of freedom of expression and free speech. And I haven't read your paper, I confess, but would assessing regulation of AI under the press clause be different in that it seems the framers were responding to the licensing of the mechanism of the press and not really speaking to kind of the institution of the press? Thanks.
Yeah, I have to confess, we did not look at the press clause with respect to our paper, but I will say that when it comes to licensing mechanisms and things of that nature, I think you can look at it under the same framework. I mean, is the government attempting to suppress intentional volitional conduct, intentional volitional speech engaged in by human beings? And I think that's oftentimes the subject of regulation. You talk about election laws, crossing over to the election law paper. Most of these things that are happening in the election context, such as deep fakes, advertisements that are intentionally altered, or photographs that are intentionally altered, those are being done by human beings using AI tools, to be sure, but they're being done by human beings for an express purpose of communicating a message or miscommunicating a message. So those are very clearly, in my mind, examples of intentional volitional speech. And I think most of what you see in terms of use cases of artificial intelligence, most of what you see will be examples of human beings deploying these tools in order to accomplish an intentional objective. And so from that perspective, I think there's a broad reach for the First Amendment when it comes to the products of artificial intelligence. The point that we were trying to make, and this may go to your question, is that we want to caution against the impulse of throwing a First Amendment blanket over the entire enterprise of artificial intelligence. All of the outputs and all the products of AI should not be sort of presumed, whether rebuttably or not, to be covered by the First Amendment, because there are instances where it escapes the tether of a connection to human volition. And we want to guard against the possibility that courts will overinterpret and over-apply the First Amendment in these cases.
Yeah, and I just would end with, I think, Professor Carrozza's helpful statement about separating for analytical purposes AI-generated content versus AI used for content moderation purposes. I think is something that is, we should explore that and understand that there's a big distinction between human actors using AI to generate the expression they intend to communicate versus this, we didn't know it was going to say that problem. That happens a lot when AI is deployed for these broad purposes of post hoc content moderation in the social media context.
Well, Ryan, Jeremy, Andy, Bartlett, Paolo, thanks so much. So ends the first panel. We will return in about 8 minutes at 10:45 for the second panel.
I guess that's what we're